Welcome to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Today, it's John Kluksdal. John focuses on medical negligence claims and is an AV preeminent peer review, rated by his peers in Martindale-Hubbell. John answers your questions about the law and how it affects you.
Are there special rules that apply to Idaho medical malpractice cases?
Yes, and for Idaho medical malpractice cases, the 2-year statute of limitation is the same as other personal injury cases. And so what our clients need to be aware of is that if you have a medical malpractice case in Idaho, you have 2 years to file your claim. And if you don't, then you lose your right to file your claim. So that's the first and maybe the most important to consider. And then there's a whole bunch of rules that are special for medical malpractice cases in Idaho. For example, I think we'll talk about this in a minute, but you have to file what's called a pre-litigation screening application with the Board of Medicine. Another rule, and maybe the most difficult of them all, is certain evidence must be presented at trial, and it must be presented specifically in accordance with the statute, or you will lose your case. And so what that statute requires is the proof regarding whether the doctor was negligent. And it says you have to provide an expert in the same specialty as the expert or the doctor who's supposedly at fault. And that person must know the local standard of care at the time the negligence was allegedly committed, and that person must testify that the doctor breached the local standard of care. So the local standard of care is important because frequently in Idaho medical malpractice cases, the medical community, the local doctors who specialize in the same field as the doctor who's allegedly at fault, they don't want to testify against another doctor. And so we have to expand our search for an expert. And you can understand why they wouldn't. They don't want to ruffle any feathers in their local community. And so we might need to go to the University of Utah or Oregon Health Sciences University or Washington University to find an expert who's willing to testify against this local expert. But that person has to establish that they have knowledge of the local standard of care. So if we're in Boise, it would be the Boise local standard of care. And so how they can do that, you might be able to establish that the standard of care is actually a national standard of care that should apply to all board-certified doctors in that field. Or you can have them talk to a local expert. That's probably the most common way we do it, where they establish with a local doctor that, yep, this is how we're supposed to do it, and our standards aren't any different. I studied at the University of Washington, and the same standard that applied there applies here, something like that. But it is hotly contested in most of my cases whether the expert can establish that they know the local standard of care. It's pretty hotly contested.
So is the expert always a medical doctor?
No, because the medical malpractice statutes apply to medical doctors. It applies to hospitals, so the nurses in hospitals. It applies to chiropractors. It applies to dentists. And so let's say it's a dental malpractice case. We still have to establish in a dental malpractice case that the local standard of care was breached. And we have to provide an expert that will say that.
Now, you mentioned local standard of care. Is it a safe assumption to say that that's documented, it's written down somewhere?
No.
Oh, really?
And that's one of the difficulties in proving it is most of the time the standard of care is this, it's a word of legal art. It's not a medical term. In the medical community, they don't have written standards of care for the most part. If a person comes in with shortness of breath and a fever, do we take an ultrasound? No, that's not written anywhere. And so, no, it's not typically written. There are some things that you could argue, well, but I have this research or this study, and it establishes the standard of care. I have had that before, but it's pretty rare. Typically, you aren't going to find it in writing that this is the standard of care that will apply specifically in this situation.
Are there limits on the damages that can be recovered?
Yes. Now, there are no limits on, for example, past and future medical bills. So if someone has $1 million in medical bills, they can recover that. There are no limits on past and future lost wages. So if a person has, some sort of really awful, terrible injury like paralysis or they're in a wheelchair for the rest of their life and they can't work, or they have a brain injury and, they're no longer able to work, then that person can recover the full amount of their past and future wages they would have earned, call it $1 million. They can recover unlimited out-of-pocket expenses. So if they need wheelchairs in the future, or something like that, and that amount ends up being a huge amount, they can recover that. However, non-economic damages in Idaho have a cap, meaning a maximum amount you can recover. And that cap started at 200, and non-economic damages are commonly referred to as pain and suffering damages. And the amount of that cap started in 2003. The Idaho legislature created a cap on non-economic damages, pain and suffering damages, and it was $250,000. It has increased. The Idaho Industrial Commission increases it each year based on standard of living and other lots of different factors they take in there. And now the cap in 2018, it's instituted every July. It changes every July. It was $357,000.
Thanks for listening to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Join us next time as they answer your questions about the law and how it affects you. They can be reached at 208-343-7510 or hepworthholzer.com.